In the last post, we discussed behavioral advertising and cookies from an international perspective. I will now be reviewing the current situation in Italy. The e-commerce directive was implemented with Legislative Decree 69 of 2012. It does reflect the wording of the European directives, including the wording of Recital 66 that maintains a reference to the right to the refuse and also the consent through browser settings. So with the reference of Recital 66 of the Cookie Directive and Section 5.3 of the e-commerce directive, we do maintain the same ambiguity that we've been discussed in our previous posts. The only difference is that there is still some room for maneuver for the Italian Data Protection Authority, the Garante as we call it. The Garante will have to provide indications on how the consent should be provided, and particularly with regards to some forms of simplified consent. In doing so, the Garante will also have to address the issue together with the relevant industry representatives. This is a great opportunity to provide clarifications and perhaps addressing some new and creative consent solutions as user-friendly as possible. As discussed in previous posts, a strict opt-in requirement in Italy would end up in paradoxes for the protection of data in Italy. The first one would be an adverse incentive. With stricter rules in Italy, the business might be inclined to transfer the processing on certain data in other jurisdictions. We all know that although certain processing can be sanctioned in the EU, in practice there's been less effective sanctioning towards non-EU companies. The second paradox would be shifting towards a more registration-based model. And through registration there would be perhaps a far more invasive processing of data. This because the overall philosophy of the protection of data is based on consent. And I still doubt whether this philosophy is based on the right approach. Because through registration, anything can basically be done. In a congress a few weeks ago, I've been discussing what alternative approach could be adopted. And we've been making an example, making an analogy with a buyer in a supermarket. Would you be happy if by purchasing a product in the supermarket, you would be asked for consent with regard to each specific ingredient? The answer is perhaps no. Of course you would want to be made aware and also to be absolutely sure that each ingredient is not harmful. But would you have sufficient knowledge to state whether overall such ingredients make the perfect combination? The same can be applied with regards to cookies. The Article 29 Working Party and also in other instances the Italian Data Protection Authority said that the user may not be sufficiently knowledgeable to address the cookie consent and fully understand what are the implications. So if this is the case, why giving so much importance to consent, and why not address these issues from another perspective? In particular, there could be some middle solutions. For instance, for certain type of cookies or certain type of technologies or certain type of processing under circumstances and with adequate safeguards, there could be an opt-out system. There could be, for instance, an opt-out system for standard advertising tools that provide guarantees also with regards to data retention or, for instance, to anonymization or, for instance, with regards to the fact that the processing is not addressed to minors or to sensitive data. For other tools, non-standard tools, there would be either a prohibition or a strict opt-in requirement. And by the way, any solution would have to be technology neutral, so as to address also future developments. So what will the Italian Data Protection Authority do? Will it just follow the guidelines provided by the Article 29 Working Party? Let's see, and we will further let you know. Thank you.